Okay, good day everyone. Today my group and I will talk about the four freedoms. Gary and Romaisa will talk about freedoms of goods, I will talk about the freedom of services, and Araksan will talk about the freedom of capital and the freedom of people. As well, we will present cases on the freedoms as examples, and we had planned to finish this presentation off with a Kahoot and a Q&A session, but unfortunately that is not possible. We hope you enjoyed this presentation and learned loads.
So I'm going to start off with freedom of goods. The abolition of customs duties and quantitative controls, as well as the prohibition of policies with an equal effect, ensure the free flow of commodities throughout the entire territory of the EU. The most important objective of the freedom of goods is the right to free flow products originating in the member states, as well as goods in free circulation in member states from third countries. Goods in free circulation are products that been important to any of the EU members, and therefore it will move freely as a product produced in the EU. Um, Moreover, treaties did not define goods as they were defined by the European Court of Justice. Goods are products that can be valued in money and which are capable of forming the subject of commercial transactions. Yeah, and additionally, financial restrictions are duties, taxes protecting domestic products. Non-financial restrictions are national laws that impose quantitative limits of foreign goods.
Now, to achieve the free movement of goods, the TFEU prohibits first custom duties between member states, which are Articles 28 and 30 of the TFEU. Second, quantitative restrictions on imports and all measures have an equivalent effect, which is Article 34 of the TFEU. The third one is quantitative restrictions as well, but in this case it's on exports and all measures have an equivalent effect, which is Article 35 of the TFEU. And lastly, the imposition directly or indirectly on the produce of other member states of any internal taxation of any kind in excess of that imposed on similar domestic products, which is Article 110 of the TFEU. Next. Mhm. Okay, custom duties forbidden. Article 28 to 30 of the TFU. Article 28 of the TFU promotes the free circulation of goods within the European Union by establishing a customs union. The customs union prohibits the charging of any duties on imports and exports within member states of the EU. Moreover, Article 30 of the TFEU not only relates to custom duties, but also applies to any charges which may have an equivalent effect. Because if there were to be an additional custom duty or charge having an equivalent effect, this would mean an inequality to the imported product as it becomes more expensive than the domestic produced product. Furthermore, duties are still payable on goods coming from third countries, but once the goods have passed through a member state, they will enjoy the same freedom of movement as goods originating within the European Union. In other words, import tariffs are harmonized and the import duties for goods coming from outside the European Union are based on a common customs tariff or CCT. In Article 30, there are two levies that are forbidden. A levy that applies only to imported or exported goods, and also the second one is a levy that applies to both imported and domestic products. However, there are two exceptions. For instance, a levy can be allowed if it is for a service required by the European law or if it's for a service that generally benefits the individual trader. For instance, it could be the cost of veterinary inspections, or for instance, during the BSE or the mad cow disease crisis, a mandatory health inspection was imposed on beef or if it benefits the trader. For instance, if the importer requests a warehouse with cooling facilities. However, even if a levy is allowed for a service required under any of these reasons, a member state is allowed to only charge the real cost of the service. Next, please. Now, quantitative restrictions on imports and exports, or Articles 34 and 35 of the TFU. Quantitative restrictions on imports and all measures having equivalent effect shall be prohibited between member states. The same provision is expected on exports on Article 35 of the TFU. Quantitative restrictions are defined as measures which amount to a total or partial restraint of, according to the circumstances, imports, exports, or of goods in transit. The Article 36 of the TFEU exempts quantitative restrictions on import and export of goods, or Articles 34 or 35, on grounds of public morality, public policy, or public security, the protection of health and life of humans, animals, or plants, the protection of national treasures possessing artistic, historic, or archaeological value, or the protection of industrial and commercial property. However, the mentioned restrictions shall not constitute a means of arbitrary discrimination or a disguised restriction on trade between member states. Direct discrimination is the quantitative restriction which do not apply equally to domestic and imported products, and this can be only justified by Article 36 of the TFU. And the second discrimination is the indirect discrimination, which are measures having equivalent effect which do apply equally to domestic and imported products. This can be justified by Article 36 of the TFEU and also by the rule of reason. The rule of reason are the justifications permitted in specific cases by the Court of Justice. The rule of reason was created after the Court of Justice of the European Union recognized the measures having an equivalent effect, that they were given a very broad interpretation, and traders were given too much power to attack almost any national rule, as member states were strictly restricted in their defense. Some examples of the rule of reason can come from the cases the Dijon and the Keck case. In these cases, the protection of consumer, the protection of the environment, the protection of fraud, and the improvement of working conditions were part of this rule of reason. And now Romaisa will explain a bit more of the Article 110.
Yes, now I will enlighten several aspects of Article 110. This article reads as follows. No member state shall impose directly or indirectly on the products of other member states any internal taxation of any kind in excess of that imposed directly or indirectly on similar domestic products. Furthermore, no member state shall impose on the products of other member states um, any internal taxation of such a nature as to afford indirectly protection to other products. Additionally, a customs duty differs from a tax in that customs duty is a fee that must be paid when goods pass a border. The taxes referred to in Article 110 TFEU are a systematic internal process of dues that are applied to different kinds of commodities regardless of their origin. Yeah, furthermore, Article 110 was initially written in the Treaty of Rome as a provision in order to be a part of a larger economic community. The Treaty of Rome was signed in 1957. As a result of this pledge, this treaty established the notion of the common market with the goal of allowing people, products, and services to easily move across borders. The removal of custom duties and numerical limits on the import and export of products between member states was supposed to allow for free movement of goods, as mentioned. Moreover, Article 110 differs from Article 30 TFEU, which was intended to prevent the application of taxes on products, often known as charges having equal effect. While they passed across member states' borders, Article 110 also was designed to prohibit protectionism from being used against goods from other EU countries after they entered a member state's borders. Furthermore, as mentioned before, there are three types of physical discrimination. There are direct discrimination, indirect I mean fiscal discrimination, not physical, my bad. Direct discrimination, indirect discrimination, and reverse discrimination. Reverse discrimination occurs when a member state imposes a greater tax on items destined for export than on the same or comparable items sold on the local market. This is quite uncommon as most countries want to export as many as possible. Yeah, furthermore, Article 110 TFEU prohibits three types of taxations. The first one, it prohibits a higher tax on imported products than on similar domestic products. So to determine whether products are comparable, the Court of Justice uses two criteria and takes a comprehensive approach. The criteria are whether the items have a comparable and equivalent use rather than whether they are absolutely identical. To determine whether two items are comparable, two factors are considered. The first one is if the objective characteristics of the products, what the objectives are. To give an example, the Court of Justice had to decide whether Scotch whiskey and fruit liquor are equivalent items in one case. Scotch whiskey and fruit liquor had distinct tax rates in Denmark. The Court of Justice concluded that in order to assess if two categories of liquids are comparable, some objective features must be considered, such as their origins, manufacturing process, the flavors, and alcohol concentration. Moreover, it must be determined whether both beverages types are able to supply the same demands from the customer perspective. The Court of Justice concluded that an examination of Scots whiskey and fruit liquor revealed that two goods are not similar. That was concluded. The right of each member state to establish tax arrangement that distinguish between specific items based on objective criteria is not limited by Article 110 TFEU. As a consequence, taxation that distinguishes between Scotch whiskey and fruit liquor complies with the TFEU standards. And another factor to consider to determine whether two items are comparable is also whether the products have similar characteristics and meet the same needs from the point of view of the consumers. Moreover, an additional type of taxation in this article is that it forbids a member state to have any internal taxation of such a nature as to afford indirect protection to domestic products. This article's second paragraph aims to avoid any type of indirect fiscal protectionism that affects important goods. And lastly, taxes benefiting mainly domestic products. And this part includes taxes and fees that are the same for both domestic and imported goods. Nevertheless, there are times when a fee that applies to both local and imported items, helps domestically produce items more than imported items and goods. Now moving on to Article 113 of the Treaty on the Functioning of the European Union, expressly allows the Council to implement regulations for the harmonization of member states' indirect taxation rules by functioning autonomously in order to comply with a specific legislative procedure and after notifying the European Parliament and the Economic and Social Committee. This is because indirect taxes can obstruct the free movement of goods and the provision of services inside an internal market right away. They also may cause competitive distortions. On the foundation of the article, a considerable number of directives and regulations have been approved in this field. The Commission's legislative plan has been established with a focus on VAT, as well as environmental and energy taxation. And now I would like to give the floor to Another team member, Gary.
Thank you, Romaisa. On the screen, we can see the case of the Commission of the European Communities, which was against the Italian Republic. So the applicant, the Commission of the European Communities, declared that the Italian Republic was collecting a levy on imports and exports, which goes against Article 30 of the TFEU. The statistical levy had to be paid when importing or exporting on every 100 kilograms or metric tons of goods, or on every animal, car, or even for goods in the smallest quantity. The Italian Republic charged 10 liras in order to have a complete record of exports and imports. Additionally, the defendant explained that the levy benefits businesses with clear and accurate information on the movement of goods. They mentioned that they are better than those from statistical institutions. On the other hand, the applicant stated that the statistical levy is a charge having an equivalent effect to custom duties because it produces a discriminatory effect as it's not imposed on goods produced in Italy that are intended for the domestic market. As this levy was imposed on almost all goods to importers and exporters, the applicant was correct when claiming that there were actually two charges having an equivalent effect to custom duties. One of them was for imports and the other one was for exports, both of them breaching Article 30 of the TFEU. Finally, as a result, the court declared that the Italian Republic failed to fulfill its obligation under Article 30 of the TFEU on levying imports and exports from and to other member states. Furthermore, after abolishment of the statistical levy, the Italian Republic had to pay for all the costs. Now, Araksan will continue with the freedom of capital.
Thank you, Gary. So I'll be discussing the freedom of capital. Article 36 TFEU prohibits all restrictions on the movement of capital between member states and between member states and third countries. This means that an individual investor or a financial institution from one member state is free to grant loans in another member state to invest in real estate or to buy securities such as bonds and shares. The reason for the incorporation of the free movement of capital in the TFEU is that a free flow of capital leads to an optimal distribution of resources and competitive European financial markets. Next slide, please. But of course, there are exceptions to free movement of capital, and they can be found in Article 65 TFEU. The article allows member states to take on necessary measures to prevent violations of national law and regulations, in particular in the field of taxation and financial institutions. Member states are also allowed to lay down procedures for the declaration of capital movements for purposes of administrative or statistical information. For example, legislation against money laundering, financing of terrorism, and a trade in narcotics. The member states also allowed to enact legislation which restricts to the movement of capital if the restrictions are justified on grounds of policy or public security. The Court of Justice found that regulations of a member state safeguarding supply in the petroleum, telecommunications, and electricity sectors in the event of a crisis would constitute a public security reason, and therefore an obstacle to the free movement of capital might be justified. So I would like to give the floor to Siofra to discuss the freedom of service.
So before we go there, a case relating. Can you go by? Thanks. A case relating to the freedom of capital is the Commission versus Spain case. Spain enacted a law DA 27 limiting the voting rights of shares held by public bodies in the Spanish undertaking within the energy sector. The law providing that during an intentional 2-month period, the voting rights of shares held by the public bodies in the Spanish undertaking operating in the energy sector were suspended. And the Spanish Council of Ministers was able to decide to not recognize the voting rights and to make excuses of these rights subject to certain conditions. Since this might deter investors of other member states from acquiring shareholders in these undertaking, the Court of Justice found the restriction in breach of the free movement of capital, Article 63 TFEU. The Court of Justice went on to consider whether these restrictions were justified on the grounds set out in Article 65 or by overriding reasons in the general interest. The court then found that it was undeniable that the objective of guaranteeing the security of energy supply in the event of a crisis is the territory of a member state would contribute a ground of public security. The court then concluded that the Spanish law DA 27 was infringement of Article 63 TFU. Moving on to the free movement of services. This refers to the right to offer services without restrictions in all member states of the European Union, found under Article 56. The justifications in respect of this right are the same justifications of the breach of free movement of goods and of persons. My apologies. These justifications of any breach of the right of free movement of services, as with the other freedoms, are only relevant if there is a measure in breach of one of the other freedoms. In other words, if there is a breach in one of the four freedoms, the exceptions of the breach of one of the four freedoms becomes irrelevant. In the freedom of services, we have the freedom of establishment. That is a part of the free movement of persons and the free movement of services. This means that a company or self-employed person based in one member state is free to set up an agency, branch, or subsidiary in other member states, and they're also free to offer services in other member states as well. The difference between the freedom of establishment and the freedom to provide service in another member state is whether their stay is temporary or permanent. In case of a permanent stay in another member state, the freedom of establishment applies, which is Article 49. And if a temporary stay in another member state, the freedom of service in another member state, which is Article 56, applies. Moving on to the freedom to provide services. In Article 56, this prohibits restrictions on freedom to provide services within the European Union in respect of nationals and member states who are established in member states other than that of a person of whom the services are intended for. The freedom to provide services only applies if the freedom of establishment does not apply, which means that if the activity is of economic nature, the services are for remuneration. The services are of short duration, or there's a cross-border element, they do apply. Moving on to the risk of social dumping. Thank you. The employment of workers who temporarily work in other member states are called poised workers, which can lead to social dumping. This means that foreign service providers can offer their services for a lower price because they pay lower wages than the service providers in the member state where the service offers. To try and avoid situations like this, the European Union created Directive 96/97 EC, also known as the Posted Workers Directive. The directive orders member states to implement legislations to ensure that posted workers are entitled by law to set a core rights in force in the host member states. Even though the workers have a contract with the sending company and are therefore bound by laws of the member state where sending company is located, the Netherlands did this in employment conditions of posted workers in the European Union Act. If you are a posted worker, you have the same right as workers from a member state, which means you get maximum work periods and minimum rest periods. You get minimum paid annual holidays and minimum rates of pay. The main issue of posted workers remains a big issue, especially in countries like France, Belgium, and Germany. These countries, there's a large part of the population who feel their jobs are stolen for them. These countries try to implement legislations to protect the workers in their representative countries from competition workers, and that puts these countries at odds with the European Commission. Next up to the main barriers of freedom of establishment and freedom to provide services. Yes, there is two. the establishment, the establishment and residence requirements. This concerns the recognition of universities and other education degrees and permissions necessary to exercise their profession. The permission to exercise profession make the freedom of establishment and freedom to provide services impossible. In such cases, the Court of Justice does not take a very understanding and lenient view of these permissions to exercise profession. On to the nationality requirements, the obligation to have a nationality of a member state in order to be able to exercise a profession or operate a company makes a free movement of persons and services impossible. Though it is forbidden for member states to make distinction between nationals and non-nationals, this discriminates between them and it's not limited by the government. It also applies to the relationship between two individuals or between a sports person and a sports federation. Thank you. Giving the floor back to Araksan.
Yes, thank you. So I will now discuss the freedom of people. Articles 45 till 55 TVEU deal with the free movement of economically active persons. Economically active persons include workers and the self-employed. The free movement of persons consists out of two parts. The free movement of workers, which are discussed in Articles 45 till 48 TVEU, and the right of establishments of nationals of a member state in the territory of another member state, such as students, former workers, job seekers, and family members. And these are discussed in Articles 49 till 55. Can you go to the next slide, please? So the free movement of workers. A worker can be defined as someone who for a certain period of time performs services for and under the direction of another person in return of remuneration. The right of the workers can be divided in different types of rights. They have the right to seek work in another member state, movement and residence rights, family rights, and finally, the workers have a market access right. Article 45 states that workers are free to move within the European Union. This means that all kinds of national legislation prohibiting workers from working in another country of the European Union is forbidden. Any discrimination based on nationality between workers of the member state regarding employment, remuneration, and other conditions of work and employment are prohibited. And this can be found in Article 45 under 2 TVEU. So Article 45 has a direct effect. A direct effect allows individuals to immediately invoke European legislation before courts, regardless of whether national law text exists. Article 45 also has a horizontal effect, meaning that a worker of a member state of the European Union can rely on Article 45 not only against national governmental authorities, but also against the employer. Moving on. A case that is example of the horizontal effect of Article 45 is the following case. So the case is about Mr. Algones, who is an Italian national whose mother tongue was German. Mr. applied for a job at a private bank in the Italian province called Bolzano. Bolzano used to be a part of the Austrian province Tyrol, but became part of Italy in 1927. At the time, the population was German-speaking, and the province largely still is. So the bank was looking for an employee who could speak both Italian and German. The applicant had to prove that he or she was bilingual by submitting a certificate of bilingualism issued by the local authorities. Mr. Anjonis argued that the requirement to prove he was bilingual by means of only one specific certificate issued in one province of a member state was in breach of Article 45 TVEU. So the Court of Justice agreed with Mr. Anjonis. The Court of Justice held that application of this rule was discriminatory and in breach of the article. This is because the certificate of bilingualism could only be obtained in one province of the member state, and non-residents in that province had therefore a little chance of acquiring the certificate, and it would be difficult or even impossible for them to gain access to the employment in question. And with this regulation, the public authority risks creating inequality in its application. So this case proves that Article 45 is also applicable to the relation between employer, in this case a bank, and employee, and in this case Mr. Angonis. Therefore, the requirement was in breach of Article 45 TFEU. Moving on. So as I mentioned before, the workers have rights. However, there are also exceptions to the free movement of persons. The first restriction on the free movement of persons is based on employment in public service. Under Article 51 TFEU, a member state can restrict access for self-employed persons to activities in which an official authority is exercised. The Court of Justice also accepts restrictions on the free movement of persons based on public security, public policy, or public health. And this can be found in Article 45 under 3 TFEU. And the last exception is that the measure does not go beyond what is necessary to attain the objective pursued. So I would like to give the floor to Romaisa.
Yeah, so on this part, we had loved to do a Kahoot with the whole class. Due to circumstances, yeah, we can't, so we'll just move on. Well, yeah, here we have represented the 4 freedoms. We thank you for listening. Hopefully it was enjoyable, and yeah, goodbye for now.